Ani, Bojo, and welcome to our video on how to create a will that Indigenous Services Canada will accept. Creating a will is an important part of estate planning and can help ensure that your wishes after death are well communicated, that your family is protected, and that your property is distributed as you intend. Creating a will can be simple to make. However, it does require some preparation to ensure it can be validated. Indigenous people living on reserve have a few conditions they'll need to meet in order for their will to be considered valid and approved by Indigenous Services Canada. In this video, we will discuss the importance of making a will and how to create a will that Indigenous Services Canada can approve, and the different types of wills that can be created. Let's start by understanding what is a will. A will is a legal document that allows you to state your wishes and intentions for the distribution of your estate after death. It can identify who will inherit from you, such as your friends, family, and community members. It will determine how your estate will be divided, who will be your executor, who will take care of your children if you have any, and in certain cases, it can identify your funeral wishes. If expressing funeral wishes in your will, make sure to discuss these arrangements with your loved ones ahead of time, as a will may not be accessible until after the funeral. If you die without a will, the rules in the law will apply based on the territory, province, and nation that you reside in. Indigenous Services Canada is responsible for estate services for First Nations in all provinces. This means that Indigenous people with Indian status who reside on reserve and die without a will must follow the regulations under the Indian Act on how their estate will be managed and distributed. Indigenous people off reserve must follow the Act, Civil Code, or procedure in the territory that they reside in. How to make a will that ISK will accept. In order to make a will, a person must be 18 years of age or older and of sound mind, which means that the person understands the nature of the document and its consequences. In certain cases, a person under 18 can make a will for property that has little or no value. According to Indigenous Services Canada, in order for a will to be approved by the minister, the will must meet 4 conditions pursuant to Section 45 of the Indian Act. The 4 conditions are that the will must be written, that the will must be signed by the testator, that the will must specify the wished intentions of the testator as to the disposition of property, and the will must be intended to take effect upon death. Let's take a closer look at what these mean. Condition 1. The will must be written. ISK will accept properly completed will forms or any written instrument which is handwritten or typewritten. This has to be completed by the testator or by another person on behalf of the testator. Essentially, it cannot be video recorded or shared verbally. There must be some form of written documentation for it to meet this first condition. Condition number 2 is that the will must be signed by the testator. The testator is the person who created the will. The testator may have written the will, but if they neglected to sign it, it cannot be accepted even if it was witnessed. If signed, it does not need to be witnessed. The second rule to this condition is that execution may be marked by an X where the testator is blind or cannot write. If it is signed by an X or by someone other than the testator, proof must be provided by affidavit or by witnesses to the actual signing of the will. Condition 3. The will must specify the wishes or intentions of the testator in disposition of property. The rule to this condition is that at least one item of the property must be given to the beneficiaries in order for it to be considered a will. For example, I wish to give my snowmobile to my Aunt Kathy. The second rule to this condition is that it may also contain wishes on non-property matters, such as childcare custody, although this will have no legal effect. Condition 4 is that the will must be intended to take effect on death. A document which gives something to somebody in the present without anything to indicate that it is to take effect upon death is not a will, but is considered a contract. For example, if you state, "I give my car to my daughter Mary," it will be considered a contract. You'll need to include the upon death in order for it to take effect. So for example, "I give my car to my daughter Mary upon death." This does not need to be included for every sentence within the will, but must be included somewhere within the will. The second rule to this condition is in the case of powers of attorney, they cannot be accepted as a will because usually power of attorneys cease to have effect upon death of the person who granted power. So how do you know which will that you need to write in order for it to be valid by Indigenous Services Canada? There are multiple types of wills, however, there are 3 common types: notarial wills, holograph wills, and wills made in the presence of witnesses. In order to be valid, each type of will must follow certain rules. Whichever type you choose, if the rules are followed, all 3 are equal when it comes to making sure your wishes are respected. Let's start with notarial wills. As the name suggests, a notarial will is a will written by a notary. Notaries can write a will that follows the legal rules and reflects your wishes and takes into account your family and financial situation. The rules of notarial wills are that they must be written in either French or in English. They must also indicate the place and date that it was made. You must sign it before the notary and a witness, and in certain cases, 2 witnesses. The will must also be read to you so that you can declare that it reflects your last wishes. The reading can take place in the presence of the witness, or if you prefer, in the presence of the notary only. Some of the advantages to this type of will is that they are harder to challenge as they are completed by a notarized professional. You also receive advice of a legal professional when completing these wills. Some of the disadvantages to this type of will is the notary fee. A notarial will can often be quite expensive to develop and create. Next is a holograph will. A holograph will must be entirely written by you and signed by you. This is the simplest kind of will because there are only 2 requirements. 1, they must be written by hand and not on a computer or using another technological means, and they must be signed by the person making the will. If you leave more than 1 holographic will, make sure that you include a date to help the executor to know which one is the most recent. These details are useful because the old will remains valid. If any parts of the old contradict the most recent one, the parts of the old will won't apply so long as there is a date indicating which one is newer. To avoid confusion, when you write a second will, make sure to include all of your wishes and to cancel all old wills. You can do this by clearly writing, "This will completely revokes any earlier wills." Some of the advantages to this will is that they can be made anywhere at any time. They also don't cost anything to make, and you don't have any professional fees to pay. Some of the disadvantages to this will is that they can be lost, destroyed, or damaged. By creating this kind of will yourself, you also don't get any legal advice. Advice can sometimes help you think about situations that you haven't yet anticipated. The third most common type of will is the will made in the presence of witnesses. As the name suggests, this kind of will must be signed in front of 2 witnesses together at the same time. Anyone 18 years of age or older can be a witness, but a person who will benefit from the will cannot be a witness. The witnesses must confirm that it is your will and your signature, and they must also sign the will after you have signed it. Some of the advantages to this will is the cost. This kind of will can be free if you don't use a lawyer or require any legal advice. However, if you do use a lawyer, there will be fees. You can also ask a lawyer to register this will. Some of the disadvantages is that they can be lost, destroyed, or damaged, and you do not necessarily receive any legal advice for this kind of will. You can choose the type of will that is right for you. As long as you meet the 4 conditions from Indigenous Services Canada, your will be valid. Miigwech.